Okay, so the new RPA December 21 release was released yesterday. Today is part 4. In part 1, we talked about the offer paragraph, the agency paragraph, and the terms of purchase and allocation of costs paragraph, which is called the grid. That is completely new, and now you'll be using the grid going forward. As you get familiar with the grid, you're going to find it very, very well organized, and it helps put all of the negotiable points of an offer in one location. So we also in part 2 finished the grid. We talked about property addenda. There are some new ones there, advisories, deposits, loans, additional financing terms, closing and possession, contingencies, items included and excluded also had some significant changes, and we went through that. And then we wrapped it up on allocation of costs. We're going to skip the next many paragraphs, 11 through 22. I'm not going to go through in detail today. That's what we'll do on the 29th. For the most part, there's not any real substantial changes in those paragraphs. There are a few little things, but it's pretty straightforward. Where the changes occur is starting in paragraph 14. There's a very helpful change to paragraph 14, subparagraphs E and G. We'll talk about that, and that's where it talks about the notice of buyer to perform, notice of seller to perform, and the DCE, the demand to close escrow. Then we're going to talk about paragraph 23. That has been substantially changed. Definition and instructions is very, very new. Some of the things in there are new. There was always a definitions paragraph in the RPA, but there's quite a bit of new information there. Terms and conditions of the offer, times of the essence, entire contract, and changes. I want to cover that just briefly. Legally authorized signer, give you a little more insight into that. And liquidated damages, mediation, and arbitration of disputes. Not a lot of changes there, but it's a couple of things I want to point out to you. The buyer's offer, which is paragraph 32, your handout says offer. It should be buyer's offer. They revised that because there's already an offer paragraph, which is paragraph 1. Acceptance, this is very, very important. We're going to review that. There's a substantial change in how acceptance occurs. And then we're going to talk about the offer not accepted, real estate broker section, and then the presentation of offer briefly. So let's get into the new RPA, those areas. This is part 4. So the first thing I want to talk about is paragraph 14E, notice to buyer or to seller to perform. And so for the most part, it starts out pretty much the same as what you're very familiar with. You know, a notice of a buyer to perform can be given, but it cannot be given more than 2 days prior to the scheduled performance day. So if a buyer is supposed to do something on day 14, you cannot give it any earlier than day 12, if it's day 14, 2 days prior to the scheduled performance. Day 17 would be day 15, and you can give the notice to perform. Now, here's what's new, and this is very helpful to have this spelled out. I have argued in the past that I think that is legally accurate, but now it's in the contract. If a notice of buyer to perform or to seller to perform is incorrectly delivered, in other words, it's delivered early, or it specifies a time other than what's in the contract, the boilerplate of the contract is 2 days. I've seen a lot of notice to perform where the listing agent puts down 1 day when it's actually 2. Sometimes we change 2 days to 3 days, and they put down 2 days, not realizing there's a change to 3 days. So they put down the wrong number of days. Well, the contract now makes it clear that's an invalid notice, and it's void. It means nothing. And the buyer or the seller, who's ever delivering the notice, would have to give a new notice with the correct specified time frame. So that is very nice to have in the contract. So if you get an incorrect notice to perform, it's like not getting one. Likewise, if you're giving them, make sure you're correct in what you put in the notice to perform. Paragraph G is demand to close escrow, and that has the same provision. So basically, before you can cancel, you have to give a demand to close escrow if you're canceling for failure to close. Do not use a notice of buyer to perform or a notice of seller to perform to compel a closing. That is very problematic, and it'll create some problems for you. It's not valid. So you use a demand to close escrow. That's what the contract requires, to compel the other party to close. And of course, you deliver the demand to close escrow, and it must be signed by the buyer or the seller, not the agent, and it must give at least 3 days after delivery to close. Now, that 3 days comes from case law. Case law requires a reasonable time period to notify the other party. You must give them a reasonable time period to perform when it comes to closing. And the smallest reasonable time in a court case has been 3 days. So that's why CAR uses 3 days. So your notice to perform must give them at least 3 days, and therefore you cannot deliver it any earlier than 3 days prior to the performance of closing the escrow. So you can't give it a week ahead of time. You have to give it within that time frame. If you want them to close on time, give it to them 3 days early. If you wait until they don't close and then you give them a notice, you have to give them 3 days. An incorrectly delivered DCE, or one that specifies a time frame less than the agreed to time frame, is invalid and void, and they would have to give you a new one. So those two changes in paragraphs E and G is very, very good. I'm very pleased to see they put that in there. All right, let's go on. Assignment, paragraph 23. Now we're skipping quite a few of the center, if you will, of the contract, only because there's not a lot of changes. And I want to get through these today because the new contract is now in place. If you're writing an offer today, if you're receiving offers today, you'll be looking at the new RPA, and I want to be sure that you're aware of some of these, what I would say, significant changes. So assignment has been changed. So a buyer has a right to make an assignment to his own or her own trust or wholly owned entity that is in existence at the time the assignment is made. So they do not need the seller's permission to do that. They should still use an assignment of agreement, an AOAA. But the seller cannot refuse to grant that. So if a buyer is deciding to buy it into their own trust, or if the buyer wants his own LLC or his own corporation to buy the property, and it's wholly owned by the buyer, then that is an automatic approval process, if you will, that cannot be turned down. Otherwise, the buyer cannot assign any part of this agreement without the written consent of the seller to the specified assignee. So these offers that say or assignee or nominee, I talked about this in a previous webinar, they are at best problematic and quite possibly invalid. Not the contract makes it invalid because you have to specify assignee. So buyers, agents who write, the name of the buyer or assignee, that assignee means nothing because it must be specified. The assignee must be specified. So they would still need to do an assignment and name the assignee. Okay, now the consent cannot be unreasonably withheld. So if there's no detriment to the seller to assigning it, I want to bring my brother onto the purchase contract with me. I want to add my wife to the purchase contract. My wife wants to add me to the purchase contract. My parents are coming on board. Those are probably reasonable assignments, and the seller cannot refuse to do that. Now, prior to the assignment, the buyer must disclose the name of the assignee and the amount of monetary consideration the buyer is getting. If so, these what they call double escrows, or these wholesale type transactions where a buyer buys the property, ties it up, and then wants to assign it to somebody the buyer is reselling it to. and they want to close escrow, bing, bing. That they want an assignment. They want to do, work in that regard, do it in that fashion. They have to disclose if they're getting money for that. Okay. Now, if they actually close escrow and then sell it to another party, that this does not apply. Okay. Now, the buyer shall provide the assignee all documents related to this transaction, including the agreement and the disclosures, but not limited to them, all documents. If the assignee is a wholly owned entity or trust of the buyer, the assignee does not need to re-sign those documents. If they are not, then they must re-sign. It's imperative that if there's an assignee other than the wholly owned entity of the buyer who signed all these disclosures, that the assignee sign all the disclosures as well. Okay. The assignee must deliver a letter from the assignee's lender that the assignee is qualified or pre-approved, just like the buyer would have had to done as specified in paragraph 6B. The buyer shall, within the time frame of 3K, and 3K is 17 days, is the boilerplate. That's the assignment request. So within 17 days, deliver any request for an assignment. So you cannot, well, you can, but the seller's not obligated to approve any assignment at the last minute. If it's not done in that 17-day window or whatever's in this blank, then the seller can withhold their consent. And their withholding of consent is not deemed unreasonable. It just causes too many problems for a seller, quite frankly, and listing agents and escrows as well, to have these last minute, day before escrow closes type assignments. So if it's not within that time frame specified in paragraph 3K, then the seller could withhold approval of the assignment. Doesn't necessarily have to, but he could. And of course, this is important. You want to use an AOAA for an assignment. Do not use an addendum, because the AOA contains an important provision that protects the seller. And that is that if the assignee cannot perform, the buyer is still obligated to perform. So assigning it to somebody does not necessarily relieve the buyer of any obligation to perform, especially if the assignee ends up not performing. The seller can go back to the buyer and say, okay, you've got to perform. Your assignee is not performing. Okay, definitions and instructions. They added the word instructions because CAR felt like some of these things weren't really definitions, but more explaining how to do something. And you'll see how that works in a minute. So first of all, acceptance. Now, you want to sort of pay attention to acceptance and delivery. They're related quite closely, and we're going to go through those. Acceptance means that at the time the offer or final counteroffer is fully executed in writing by the recipient party and delivered to the offering party. So if an offer is accepted by the seller without a counteroffer, then acceptance is when the seller executes the offer and delivers it to the buyer. If the seller does a counter, then acceptance would be when the buyer signs the counter and delivers the signed counter back to the seller, because the seller is the offering party of the counter. Or the party's authorized agent. That's a big change. The old RPA, you had to name the agent. In the new RPA, you don't name the agent, or you name who the authorized agent is, and you'll see that in a few minutes. But you don't have to name that agent in the acceptance paragraph. Obviously, you can see it's not there. When we get to the acceptance paragraph, you'll see it's not there. Okay, so agent, different than authorized agent. Agent means the broker, the salesperson, or a broker associate, or any other real estate licensee whose license is under the brokerage firm. So agent is sort of company-wide, broker-wide. Everybody within RE/MAX Connections is a RE/MAX Connections agent. So when the word agent appears, it could be any person within RE/MAX Connections. So for example, an agent, the buyer's agent must do a visual inspection. So can the buyer's the buyer's agent who's working with the buyer designate somebody within the company to do that AVID for them? Yes, they can, because the agent must do the visual inspection, not the authorized agent. The authorized agent, you'll see, is the individual who's actually working with that specific buyer. Okay, so broker, sales associate, any other licensee licensed under the broker firm that's identified in paragraph 2B up at the beginning where you name the brokerage. They are all agents. Okay, so that's paragraph 2B right there. So the anybody associated with the brokerage firm is a seller's agent. Anybody associated with the buyer's brokerage firm is a buyer's agent. That's a very important legal nuance, and especially important in reviewing the RPA. So the authorized agent means the individual real estate agent, licensee, specified in the real estate broker section. That's at the end of the RPA. The real estate broker section looks like that. And so the buyer's brokerage firm is named up on the top line, above my red box. And then the individual agent working with the buyer, there's two of them, two agents, they're identified. So those are authorized agents. So back to acceptance, when the authorized agent receives the executed document, not the agent, because the agent would be anybody in the brokerage, but the authorized agent would be the agent working with the specific principal. And same with the seller's brokerage firm. They're named. You'll see that on page 16, real estate broker sections, they're named. Okay. So as is, I want to just mention this, please avoid as is. I was listening to a CAR webinar and I was pleased to once again listen. I've heard this before and they again reiterated, although it's not illegal to specify as is in a contract. In fact, the boilerplate of the contract says as is. It can be problematic writing it in a counter offer. So you should avoid it. If you do it, it's not the end of the world, but there are problems with an as is provision written into the offer. If it's written into the counter offer, I'm sorry, most buyers don't write as is on the offer. It's already in there in the boilerplate, but sometimes sellers agents will counter it. Now, there's two problems with that. The first problem is the one I experience most often, and that is when the seller directs his agent to write as is in the contract, and there's not a discussion with the seller about that, the seller has a tendency to think that somehow reduces their obligation to make disclosures. What difference does it make the properties as is? It makes all the difference in the world. The buyer still gets to know what is. And so the seller must still make all the disclosures that they're required to make. And so writing as is on a counter, I can tell you psychologically has not the best effect on the seller. They tend to think that now their obligations to disclose are somewhat lessened, and they are not. Now, as a buyer's agent, if your offer contained a repair request in the offer, and the most common would be we still have agents, and I'm not opposed to it. CAR doesn't like it, but as long as the listing agent pays attention to what they're obligating their seller to do, if a buyer wants a clear termite and they write that in the offer, and the seller counters back as is, that removes the obligation to make that repair. And providing a clear termite is a repair if something has to be done to the house to get it. If it needs to be tented, if their dry rot fascia boards have to be removed, that is by definition a repair, and as is means no repairs will be made. They're not obligated to make repairs. So when a seller counters an offer where the offer contains a repair provision, like for example, another one that's common is certify the septic. Well, as is being countered back means they're not You don't have to do anything to the septic. Now, if a SWIPy is used, they wouldn't have to anyway if they don't approve the price. But most of you who sell properties with septic tanks understand that if you don't sell property with septic tanks too often and you are involved in a transaction where there's a septic tank, good idea to reach out to one of the managers or call me and let us give you a few pointers about working with properties with septic. Some of our agents do a lot of that. Some of our agents do none of that. So, okay. As is, seller shall disclose all material facts. The buyer has the right to inspect the property and make requests for repairs. Sellers only required. Yes.
I was just wondering, because you were saying you don't want us to use the as is, but when they ask for something like the termite, it's okay then to counter back and say,
no,
shall be sold as is. Is that what you're saying?
No, I'm not saying that. I'm saying that if you are the buyer's agent, you get back a counter that says as is, that means you're not going to make repairs. If you want a counter, if they ask for a termite repair in the counter and you don't want to provide that termite repair, that clearance, specifically counter it out. I don't recommend you use the as is clause. If you wrote as is, though, the buyer would have to understand that you're not making the repair. But CAR will tell you it's much better to be specific. So here comes an offer. It says provide clear termite. Seller doesn't want to provide clear termite. Just counter it out. Seller shall not be responsible for providing clear termite. You delete that provision from the offer. Yeah. Okay.
Walt, so much.
Yes.
Does it clear that all up if the seller really wants to sell as is? If you put in the MLS listing, property sold in as is condition, no repairs will be.
Right. Well, first of all, the fact that you put in the MLS listing, all that is just an advert, sort of a notice that the seller is not going to agree to repairs. But the MLS listing is not part of the contract, so that doesn't give the seller any additional protection whatsoever. Putting it in the MLS, you might be notifying somebody, look, we're not going to make repairs. You could put that in the MLS. The seller's not obligated to make repairs anyway. So, maybe as a pre-notice, look, if you're buying this and you're thinking we're going to make repairs, I'm telling you we're not. That's probably about the only good reason to use as is ahead of time, or to put it in the contract just to remind the buyer that you're not going to make repairs. But I would avoid the phrase as is and just say seller shall not make repairs.
Okay. See, thank you.
Avoiding as is as much as possible is the safest way to go. And you're not giving your seller any additional protection, pre-establishing that it's as is, because it's already in the contract. So you don't really need to even add it. That clarified for everybody?
Yes, thanks.
Okay, good. All right. So next, counting days. I get this question all the time, and I'm just going to try to explain it. I don't think I underlined anything else in this paragraph. This paragraph kind of does explain it, but counting days, the first thing I want to point out, I still get this from time to time. Hours has been removed from the contract. So in an older RPA version, they had like a 72-hour clause, 48 hours, all of those kinds of issues, within 24 hours. And they took that out because the problem was, there was a fight when, it was 11:59. Is that 12 or is that 11, 12:50? I mean, it was just, people looking at their clock and counting minutes, and it was creating a lot of problems. So they removed hours from the contract. So everything is an entire day. So a day lasts from midnight. Midnight is the first second of a new day to 11:59 p.m. So, 12 a.m. is the very first second of the new day, and 11:59 is the very last minute of the new day of the day. So, in counting days, with the exception of the buyer's deposit going to escrow, that's the only business day in the offer. every other reference to days is calendar days. And the way you count days is the day, the beginning day, the day the event occurred, like acceptance. So acceptance was happened today. The seller signed the buyer's offer, and we delivered it back to the buyer. And so today is day 0. So day 0 is, it's just like if you deliver a notice to buyer to perform and you deliver it to them today is day 0. So the first day of the thing you're counting out is always 0. And then each day after that is the full day. So if I gave somebody a notice to perform this morning at 10 o'clock, then day 1 would be tomorrow, and it would start at midnight and go till 11:59 p.m. Day 2 would be Friday and would go until 11:59 p.m. And so the buyer would have till 11:59 p.m. to remove their contingencies. If I gave them a notice to perform today, to remove contingencies. Now, where you skip weekends and holidays is the last day of performance. So if I give a notice to perform tomorrow's Thursday, tomorrow is day 0. Doesn't matter what time I give it to them. If I give it to them at 11:59 p.m. tomorrow night, the next day, Friday, is day 1. If I give it to them at 6 in the morning tomorrow doesn't count. Thursday doesn't count. Day 1 is Friday. Now, day 2 would not be Saturday or Sunday. And if Monday were a holiday, it would not be Monday. The last day of performance cannot be a weekend or holiday for counting day purposes. So giving a notice to perform tomorrow's Thursday, day 0, 2-day notice to perform. Friday's day 1. Saturday doesn't count. Sunday doesn't count. Monday is day 2. They would have until 11:59 p.m. Monday. And if Monday were a holiday, it would bleed into Tuesday. Hope that's clear to everybody. That's how you count days. All right, so let's, and day means the entire calendar day. It's not, with the exception of deposits, which is a business day, as I mentioned.
Quick question.
Yes.
Yeah.
With the demand to close escrow that you referenced earlier is a 3-day notice.
Right.
And if you got that delivered on Thursday, Friday being day number 1, Saturday and Sunday would still count as days, but not be able to kick in until Monday. Is that correct?
No.
Well, I'm not, let me reword you. Let me answer the question. I'm not sure how you said it, but if you got a demand to close escrow tomorrow, Thursday, Friday would be day 1, Saturday would be day 2, and Sunday would not be day 3.
That's what
Monday would be day 3.
That's
right. Right. Yeah. So all of the calendar days count except the last day. So, and of course, if escrow is not open, elsewhere in the contract, it states that if escrow is not open, then the close of escrow goes to the next business day. I'm sorry, not escrow. If the county recorder is not open, then that day cannot count as a last day. So let's say Wednesday's a holiday. So you give demand to close on Saturday, Sunday's day 1, Tuesday's or Monday's day 1. You gave it on Saturday, Sunday's day 1, Monday's day 2, Tuesday's day 3, they got to close. But if you gave it on Sunday, Monday's day 1, Tuesday's day 2, Wednesday's day 3, it's a calendar day. It's not a holiday except the county recorder's closed. It's a county recorder holiday. So that would not count if the county recorder is closed. That makes sense to everybody? Okay. Delivery. Now, delivery has changed substantially. And I don't want to I don't want to be too negative here, but I suspect we're going to have problems going forward. So there are some things you're going to want to do to avoid some obvious problems. But I still think it's going to be a little bit interesting to see how this shakes out. It's going to take a year or two before lawsuits are filed and things get straightened out. I'm just a little concerned, quite frankly, about the way delivery works. Okay, so delivery shall be effective upon personal receipt of the document by the seller or the buyer or their authorized agent. So not any old agent or any young agent, but the agent named in the broker section, paragraph 16 that I showed you, and I'll show it to you again. That named agent, if that agent receives it, that's delivery. If the buyer or the seller, and they're the principal, they receive it, that's delivery. So that never changes. And so personal receipt means a copy of the document or an applicable link to the document is in the possession of the party or the authorized agent, regardless of how the method of delivery was used. So if the agent actually has a copy of the link, then, so you're giving documents and you're uploading them all to one giant file and it's too big to email. So you put it on the cloud and give them a link. When that link is in possession of the authorized agent, that is delivery. Okay. Now, an electronic copy of a document or a link to the document that has been sent to any designated electronic delivery address specified in the real estate broker section, page 16. I showed it to you before. I'll show it to you again. That is delivery. Notice the key word here, sent, not received by the party. So what this contract assumes, and it is, I understand why it's written this way, because this is kind of how courts are looking at email. Courts sort of believe if you emailed it, it got there. If you can document that it went out to a valid email address. If it went to a valid email address that was somehow, associated to the recipient, then them saying, oh, gee, I didn't open it, or gee, my email was down, gee, I had trouble, my computer didn't work, I was away for the weekend, I didn't check my email until Monday. All those arguments go out the window because delivery is the minute or the second even it's sent to a valid address. So as listing agents or buyer's agents, actually, I would argue both sides, of course, you're going to want to pay attention to your email when you are in contract, because if anybody sends you a document, if it goes to your spam folder, that is not a defense against delivery. Too bad. It was sent to a valid address. The fact that your program somehow thought that was a spam email is not going to protect you. So this is going to be, I suspect, a little problematic till we get used to it. It'll work beautifully when agents want to cooperate. But here's my concern, and just so if you have problems, call me and be sure you're paying attention to this. My concern is it's not the transactions that don't have problems aren't where the problem's going to be. Problem's going to be where somebody's trying to claim I didn't get it. And, that's going to work pretty, the presumption is going to be against the recipient, because if it's been sent, you got it. It's as simple as that. So that's where I think we're going to have a little bit of struggle going forward. All right. So that is a paragraph, page 16. Lindsay emailed you the booklet, and of course it's available. The RPA is available. You should get a copy of it and look at it. So on paragraph 6 or page 16, the real estate brokers section, there are designated delivery addresses. So you put in an email. You can have an alternate email. You can check the box if you want the delivery to go to the alternate. Why would there be two? CAR was concerned that the email address might auto load. And so, and that might be an email address you use for marketing purposes. Maybe it's part of your MLS email setup, and that ends up auto loading. So they're telling agents, and I agree, pay attention to the offer. And if you see an email address that's not correct, you're going to want to counter in an alternate or advise the other party that there is an alternate email that you would like them to use. And then, of course, check the box for alternate. Likewise, along the same lines, there's also one for seller's firm. If this is blank, you should counter in that must be provided, because that is how you're going to effectively make delivery. And if they don't give you an email address or there's not one here, then because the contract says the email address listed in the broker real estate section, page 16, and if one's not listed, you should counter that needs to be provided. So if call me if you're having problems with agents providing you offers or listing agents are not providing you email addresses that you can then point to as the bona fide delivery address, if you will. Okay. After acceptance, an agent may change the designated electronic delivery address for the activity in writing and deliver the notice to the other party. So if you have one email address for, in the offer, but now you want to change it, you can do that. The contract allows you to do it. Now, if a recipient of a link is unable or unwilling to open a link, it's going to be another, I think, problematic area, because some people just don't want to open links or have problems opening links, and links sometimes are problematic. I think all of us have experienced from time to time a link not working. So if a link doesn't work or you can't open it, you must notify the sender in writing within 3 days of delivery of that link that you couldn't open the link or you're refusing to open the link. I can see some principals saying, I'm not opening any links. I don't know, there's not, some sort of malware in that link. I refuse to open them. And in which case, the delivery will be effective upon the documents. The person sending the link would have to then break up the documents into bite-sized pieces that could be emailed and send them not via a link if they get a notice within 3 days of the delivery of the link to that they're not going to be opening the link, that the other party is not going to be opening the link. That makes sense to anybody, everybody, and anybody. Okay. So if you have questions, go ahead and.
Well,
yes.
On number 16, why is it not listing authorized agent? So you're putting your license number in there as the broker and the agent, but not necessarily the authorized agent.
No, that is the authorized agent, because the contract defines the authorized agent as the names that appear on these blanks.
Okay.
So by definition, they are the authorized agents.
Okay.
The agent is the brokerage firm and any agent associated with. That's agent. So the agent is RE/MAX Connections, and every one of us are an agent to all of our clients. And that's always been the law. A lot of agents, it's kind of a nuance that a lot of agents don't really think about. But, that's when you have one agent in the company representing the buyer and the other agent in the company representing the seller. I tell agents, don't ever use, well, I represent just you. No, you don't. You represent everybody else. You're just not working with everybody else. You are working with the buyer, but you are an agent of every client that every other agent in this company has. Don't get too bogged down there, because your head will explode. But that's agent. Agent is broker specific. Authorized agent is the individual named in the real estate broker section, page 16, by definition. Okay, that help?
Yes, thanks.
Okay, good. Okay. All right. So delivery is quite a bit different than what it used to be. So And by the way, failure to notify the sender within the time specified above, which is 3 days, then the party is deemed to have received the link. Okay, legal authorized signer is also defined, and that means individual who has authority to sign for a principal. So a principal might be an LLC, that's the buyer. That's the entity buying the property. The legal authorized signer is a person within the LLC who is empowered to make acquisitions. A legal authorized signer could be holding a power of attorney. A legal authorized signer could be a trustee. So it's the individual who has the authority to sign for the stated buyer. Okay, so now where is that discussed? That's discussed now on the offer rather than in a separate RCSD. So you do not need an RCSD with an offer. If you have an entity buyer, you simply fill out the RCSD portion in paragraph 32, and you identify paragraph B3, you identify who the legal authorized signer is. And I'll talk about that in a little more detail. Same with the seller. Terms and conditions of the offer. One thing I just want to touch on here is that liquidated damages and arbitration of disputes requires initials. And to be incorporated, it must be initialed by all the parties or incorporated through a counter offer. So, buyer sends a offer and does not initial arbitration, and the seller wants arbitration, or does not initial liquidated damages and the seller wants it, then the seller would have to counter it in, because there needs to be mutual agreement, and you have to document that both parties agreed to it. And only one set of initials in the RPA is actually evidence that there wasn't mutual agreement at the time the document was executed. Okay, so if at least one, but not all parties initiate a counter initial, rather, if at least one, but not all parties initial the liquidated damages or arbitration dispute, then a counter offer is required. So I wanted to point that out. Now, time is of the essence. There's not a big change there, but this has been pointed out, and I can't tell you how often, kind of, not good, but how often agents will tell me that a buyer or seller is obligated to do something. Why? Because I have an email. No, doesn't work that way. Neither this agreement nor any provision in it may be extended, amended, modified, or altered, or changed except in writing signed by the buyer and the seller. So, it has to be reduced to an addendum. Having an email, yeah, you can do X, Y, Z. Yeah, we're going to leave, the gazebo or the spa. After all, you want us to leave it. Well, we were going to take it, but yeah, we'll leave it. But you don't memorialize it. Yeah, you can have an extra 5 days. You don't, all the things that sometimes get discussed in a contract, and then maybe one party sort of commits in an email to the other party they're going to do something, but no addendum was generated, and then the party doesn't do what they said they would do, you got nothing. You really don't, because the contract's very clear. It must be amended in writing and signed by both entities. Agents cannot bind buyers or sellers. Well, the listing agent sent me an email and said the seller would do X, Y, Z. Doesn't count. So I want to point that out. Legal authorized signer, wanted to point this out. The legal authorized signer, number one, represents that the entity for which they are signing already exists and is in good standing to do business in California, and shall deliver to the other party and the escrow holder within 3 days of acceptance evidence of authority to act. An RCSD is not evidence of authority. It simply notifies you that that they have authority, and this is, who they are, and this is the entity granting them authority, but it's not evidence that they have the authority. Evidence of authority would be a certification of trust or copy of trust or a document, a letterhead from the LLC saying Sally has the authority, the authorization to acquire property for the LLC or the corporation, or if somebody says I have a power of attorney and they put that in the RCSD section of the offer or a separate standalone RCSD, they still have to provide you a copy of the power of attorney. So evidence of that authority must be provided within 3 days. I wanted to point that out as well. Liquidated damages, not a lot's changed there, but I want to take a moment to point something out. If the buyer fails to complete the purchase contract because of the buyer's default, the seller shall retain as liquidated damages the deposit actually paid. Okay. However, only if the property is a dwelling with no more than 4 units, one of which the buyer intends to occupy, then the amount retained shall be no more than 3% of the purchase price. So investor buyers who put down a 5% deposit thinking, well, the worst I'm going to lose is only 3%. No, you could lose the entire amount. And if it's a commercial property or land, then the 3% does not apply. I wanted to point that out to you. Now, at the time of any increased deposit, the buyer and the seller shall execute a separate DID to incorporate the increased deposit into liquidated damages. Okay, mediation. Now notice liquidated damages requires buyer and seller's initials. So it doesn't exist unless both parties initial or is countered in if one party hadn't initialed it. So the seller wants it, the buyer didn't initial it with the offer, the seller would counter it in the counter. Mediation, notice there's no initials. Mediation is part of the boilerplate. It's there automatically. The parties agree to mediate any dispute arising out of this agreement before going to court. All right. Now, interestingly enough, the parties also agree to mediate a dispute with the real estate agents if the real estate agents in writing agree to mediation. So we're not bound to mediation. Well, I can tell you as a practical matter, we would go to mediation, of course, but we're not bound by it. But we can be asked to mediate. We cannot be compelled to mediate. Okay. Now, if after dispute arises, a party commences action without first attempting to resolve the matter through mediation, then refuses to mediate after a request has been made to mediate by the other party, that party who is not participating in mediation shall not be entitled to recover attorney fees. So a party who does not want to mediate, they have every right not to mediate. There's no law that says you have to mediate. The contract says if you refuse to mediate and you win, you will not get your attorney fees. And the courts will hold that up. That will be something the courts would recognize. So now there's an exclusion from mediation. I get this all the time. Well, they want to sue me in small claims court. Well, they want to sue the seller in small claims court, but we have to mediate first. No, you don't. The exclusion is any exclusion identified in 31B, which is the arbitration clause, and it lists exclusions. And notice that small claims courts are exempt from the requirement of the either party being compelled to mediate. Now, I will tell you, when you go to small claims court, the judge is going to have you mediate out in the hallway anyway, so you'll end up doing a quick and simple mediation. But, you do not have to mediate before filing a small claims action. Okay. Now, an arbitration of disputes, it's the same, it's the same exclusion for arbitration. And that is, you do not have to arbitrate if you take something to small claims court. And there are other courts that are listed, but you're not going to be involved in those. Unlawful detainer, some agents might be involved in doing property management. And some agents might be doing judicial or non-judicial foreclosure, and that does not have to be mediated. Nor does probate have to be mediated or bankruptcy have to be mediated. Okay. Now, this is important. I want to point out, agents, I would caution you to not arbitrarily recommend arbitration. You might believe arbitration's a great deal and your client should do it, but if your clients ask you, should we initial this? Your answer should be, well, I can't give you legal advice, and there are specific benefits and possibly drawbacks to arbitration. There's a booklet that I put in Agent Hub. It's written by C.A.R. I maintain the C.A.R. copyright, but I cleaned it up a little bit, the look of it. I didn't change a word of what was written. And that's in C.A.R. and it's the buyer's or the consumer's guide to arbitration. And it's about a 4-page little pamphlet, and it does an excellent job of telling you why arbitration is good and why arbitration may not be so good. One of the things that people don't realize in recommending arbitration is you have no right of appeal. So a party who loses an arbitration and is adamantly, believing they shouldn't have lost, and they get an attorney, or their attorney tells them, well, you can't appeal this, sorry. Why did you initial arbitration? Well, my agent told me it's a good idea. That will be very problematic. It has actually happened a couple of times over the years. So one of my little soapbox speeches is, don't recommend arbitration. You can tell them, look, some people like it, other people may not like it. I personally don't like arbitration. Why? Because I like that appeal. I can always decide to arbitrate later, but I'm not going to agree up front to arbitrate. That's my own personal opinion. By the way, I will tell you, majority of attorneys don't like arbitration for the same reason. Also, your discovery rights are somewhat diminished in arbitration. So that can be problematic, possibly. I'm not here to tell you arbitration is a bad thing. It's a preference. You either are for it or not so much for it. And recommending it without first telling the client there are some drawbacks, I think the appeal is a big thing. So I wanted to point that out. Look at the booklet in Agent Hub, download that, give it to your clients, especially if they ask you, well, should we initial this or not? I always recommend it. You should have a copy of it available to send to your client when you write the offer. If they say, well, what about arbitration? What do we do about that? Well, let me send you a little booklet here that our Association of Realtors makes available. Okay. Buyer's offer. Yes.
Well, really fast. So you can initial liquidated damages and not initial arbitration. That's correct.
That's correct. Right. They're separate. They're separate blocked on the same page, but blocked separately. Right. Right. And again, I'm not going to tell you not to arbitrate. Some people like it. Many people, probably more people like it than don't like it. I just want to be sure that agents are aware that it's not a panacea. It's not a perfect solution. It's some drawbacks. Okay.
Well, I have a question.
Yes.
If you are sending offers, whatever listings through DocuSign, and you have to fill in where they sign, they can't finalize the document with that. So what's your liability on that? If you know what I mean, you're putting the initial there for them.
Well, here's my belief, and I don't want to step on any toes, but I believe agents do not counsel their buyers as much. Some do, but some don't. I personally would never have a buyer execute a DocuSign offer without me first reviewing the offer with them. Because, and I would say, you practically have to, right? What price do you want to put in? When do you want to close escrow? What about this? What about that? And so before I'm sending off an offer in DocuSign, I've talked to my client about the offer. Now, what people are not doing is talking to them about arbitration. Now, maybe you will. Now, do you want to agree to arbitration or not? If they say, yeah, I want arbitration, well, then, don't rattle their cage. Well, do you know there might be a problem? I wouldn't do that. But if they say, what do you think? Here's what I also wouldn't do. Oh, yeah, arbitration saves you money. It's quicker. Yeah, doesn't necessarily save you money. We were in a lawsuit that required arbitration for 2.5 years. Our attorney bill was $100,000. That, if it had gone all the way, it would have been arbitrated. So did it save money? Not much. Did it go fast? 2.5 years. So to say, oh yeah, it's a good thing as a blanket statement is what I'm preaching against. So to answer your question, just like before you send the DocuSign offer over, you're going to have ask the buyer, what do you want to pay? You're going to ask the buyer, when do you want to close? And a few other questions, quite frankly. One of those questions should be, do you want to initial liquidated damages? Yeah, no. Do you want to initial arbitration? Yeah, no. What do you think? Well, let me send you a little booklet about arbitration. Then you decide. That help?
Yes, thank you.
Okay, all right, good. Okay, so the buyer's offer, that's what the RPA says. This I made this slide before they made the last edit, a couple of minor edits to the RPA. So it used to say offer, and then they discovered there's already a paragraph 1 offer, so they had to rename this offer. Okay, so the first thing it talks about is expiration of offer, and that's according to paragraph 3C in the grid. Offer expires in 3 days of all buyer signatures. So the last signature on the offer starts the 3 days, and the day that they signed it, the last signature is day 0. See how that would be? So day 1 would be the next day after the date of the last buyer signature. Okay, if the offer is signed the offer is signed by a seller, a copy of signed offer is delivered to the buyer or the buyer's agent. It expires unless this is accomplished. If this is not accomplished in that 3-day window, then it expires. The seller, by the way, has no obligation to respond to an offer. That's pointed out as well. Now, entity buyers, if you have an entity buyer, now you just check this and you no longer need this, provide the RCSD. Other is also was removed. There is no other on the RPA. So one or more of the buyers is either a trust, a corporation, LLC, probate estate, partnership, or someone holding power of attorney. And so that's just stating that. And so this blank, ignore this blank, this whole line went away in the RPA that you're looking at right now. This agreement is being signed by a legally authorized signer in a representative capacity and not in an individual capacity. Again, this is an informational clause. This is not an authority clause, as I said before. So you are simply informing the other party that, the person signing this is signing it as an authorized signer. You are not documenting they have the authority to do that. So now you name the authorized signer right here. That'll be the name of the person who holds the power of attorney. That'll be the name of the VP who has the authority to buy property. That'll be, the name of the trustee. And of course, if it's a trust, then you identify the entity in total. And if it's a probate, you include the case number, and you have 2 blanks to list the entire title of the trust or the entity. On page 1 of the RPA, you can use a simplified abbreviation, if you will, of the trust, the Jones Family Trust. But in this, you would list the whole complete title, Jones Family Trust, dated such and such a date. That would be the entire the entire actual title of that person. Okay, and then finally, on the buyer offer section here, they point out to the buyer, look, this is 16 pages. So you got all 16 pages. Make sure you read and understand all 16 pages and any attachments that are part of the agreement. And then the buyer signs, signature of the buyer, and acceptance. Now, okay, that's the offer is made. Now acceptance of the offer. The seller warrants that the seller is the owner of the property and they agree to the above terms and conditions unless they want to counter. So the seller's acceptance is subject to an attached counter. You would or multiple counting, you check that box. If it's subject to a backup offer, I'm already in an offer, but I'll take yours as a backup offer and use the backup offer addendum along with that. And then so you have a counter as part of the backup offer, or it can be both. You can have multiple counter offers. You're already in escrow. We got two other people still want to buy it, so you can counter both of them as multiple counter offers. And either one of them, they're a backup position because you're already in escrow with a primary offer. Okay. And now the other point too, the seller shall return the entire agreement with any response. And that's especially important so you can see if those other paragraphs are initialed or not. But you also want to document that the buyer got the entire agreement, initialed all the pages of the entire agreement, so there's no problem later of some page being missing or something like that. So you want to make that your practice, that the seller returns the entire document back, not just the counter offer. Okay, and then entity sellers, it's the exact same thing as it is with buyers. One or more of the sellers is a trust, corporation, LLC, probate, partnership, or hold the power of attorney. There is an other in that blank if you have another entity. The agreement is being signed by the legal authorized signer who's acting in a representative capacity. Again, this is not an authority document. This is an information clause. The name of the authorized signer is listed here, and then the total complete name of the entity is listed on those blanks. And then again, the seller is also acknowledging there's 16 pages. And then finally, we're almost done here. Finally, at the very end of the page 15 is offer not accepted. Now, there's no requirement for that to be filled in, but it's a nice practice. They removed the word rejected. They thought that was too harsh. Makes me smile, but they replaced it with not accepted. Seller initials it. There's no counter offer and the date. And that's a nice friendly thing to do to your fellow agents. If your seller is not going to accept an offer, return this page to them so that they can go back to their buyer. Buyers at first, and most of you have been there, you know what I'm saying is true. The first day or two, the buyer's mad at the listing agent because we're not getting a response. Within a week, the buyer is now mad at their own agent. What's wrong with you? You can't get a response. And so you're kind of hurting buyers' agents that you want to cooperate with in a future transaction by not helping the buyer's agent tell the buyer, look, sorry, the seller didn't accept your offer. Simple as that. They're not making a counter. Okay. There it is. All right. Now, seller's broker section. We talked about this before. This is page 16 of the offer. And that is where the agent's signatures and designated electronic delivery addresses occur. So you name the specific agents here and you name their electronic delivery address down here. And I would recommend that if that's not part of the deal, part of the transaction early on, you want to get that this information very, very early because you're going to want to make deliveries to do that. So that's where the authorized agents are identified, and they sign it and they date it with their license numbers. If there's more than one agent in the same company, it's an AAA. If they're in different companies, an ABA. Okay, so it's more than one firm representing the buyer. If the same firm, two of you are partnered up and both of you are RE/MAX connections, you use the AAA. And then the delivery addresses. Same with the seller, and same with adding an AAA or ABA if necessary, and then finally providing the delivery addresses. And then finally, presentation of offer, the very bottom of page 16. If the seller is refusing to respond or chooses not to respond to an offer, they have no obligation to respond. At the very least, the listing agent, the broker or the designee, that could be the listing agent, can initial and state that, yes, it was presented to seller in such and such a date. And again, professional courtesy, do that then at the very least. Folks, that wraps it up.
First question was from Sharon. Can we put in the offer that the authorized agent must perform the AVID?
Can you put that in? You can. I don't know that you can enforce it, quite frankly. In fact, CAR will tell you that if somebody does AVIDs real well, it's not a bad idea for the brokerage to have that person do all AVIDs. So can you put it in? Yeah, of course you can put it in. If they refuse to, can you enforce it? I don't think so, because it's license law. The representative of the entity is the broker and all of the broker's agents. So you can't really say, nope, but that agent's not going to be a part of your brokerage for contract purposes. Does that answer your question, Sharon? I guess the right answer would be I probably wouldn't do it. I mean, you put it in, and if they don't do it, maybe that's the way to go. Put it in, and if they don't do it, I wouldn't fight them, because you wouldn't win that fight ultimately.
Walt?
Yes.
Another question, just if you have a buyer that is given a notice to perform, and the buyer just doesn't want to act on it, just says, legally, what are they going to do for it? I'm going to close escrow. So just because they say, give me that contingency removal in 2 days, if I know I'm going to do it in 3 days or 4 days, what's going to happen if I just, pass this time? And
well, you run the risk. I mean, this is always a problem with a notice of buyer to perform or seller to perform. The remedy is canceling. So if a buyer says, yeah, I got a notice to perform, I don't care, I'm not removing contingencies, the remedy for the seller is only to cancel. And if you don't have another offer, if you don't want to go back on the market, if they're going to close 3 days late, but it looks like they're going to close, you don't really have a remedy. So,
right.
I hope this is okay to say on a recording. We'll have to edit it out if we can't.
You can call me.
One of my best friend attorneys' favorite expression would be when he'd have bad news for a buyer, in this case, bad news for a seller. Gee, I'm sorry, Mr. Seller. All you can do is cancel. This buyer, you can't take a gun over there and make him remove contingencies. All you can do is cancel. And then the seller complains. Then the attorney would say, sometimes it sucks to be a seller. It's the same time where you have to give all inspection reports, right? So you have a buyer gets an inspection report. He doesn't like it. It's a horrible inspection report. Maybe it was done poorly. You have to give it to the next buyer. Sellers sometimes object to that. Well, I'm not an attorney, but I'm telling you got to give it to the next buyer. So when they talk to our attorney says, yeah, you have to give it to the next buyer. Sometimes it sucks to be a seller.
And the buyer doesn't have to agree to cancel. The buyer can hold it up.
No. Okay, that's a great question, Libby. Now, this is not understood very well, but cancellation is a unilateral act of the offer. That's a unilateral act. I mean, think about it. The buyer can't get his loan. The lender says, no, you got bad credit. The seller says, I don't care. You're not canceling. See, the buyer has the unilateral right to cancel. Now, if you are exercising that right inappropriately, you might have a problem.
Right.
You can cancel. The seller can cancel if the buyer does not remove contingencies. Now,
yes, the seller can
close. If the buyer can close the next day, I would tell the seller, you might want to not cancel, because the judge might have sympathy for the buyer because he can close the next day. And, you didn't really, contract to have contingencies removed. You contract to sell the house. But if you've got to go get another buyer, you don't need this buyer to agree to your contract cancellation. You might need his agreement to close with the next buyer because you don't want to be sued by that first buyer. But cancellation is a unilateral act, or can be a unilateral act of the offer. Now, canceling escrow is mutual, but not canceling a contract. Buyer can cancel if the seller doesn't perform. Seller can cancel if buyer doesn't perform. Before you sell the house to somebody else, make sure your cancellation was you had grounds to cancel. So that's why, you do backup offers and you tell buyers or sellers rather, before you close with that backup offer, you need to have an attorney tell you you're okay, because you close with that backup offer and then a judge gives the first buyer the right to proceed, you're going to owe that buyer damages. Does that help?
That did. Thank you.
Yeah. Okay.
Libby had another question earlier in the chat. How about writing as is?
We got that answered.
Okay.
Yeah. Thank you.
Perfect. Darcy also wrote, why not just say in the counter offer, seller will not do repairs? That's better, Darcy. I would agree to that. Yeah. That's exactly. And that's what CAR says too. CAR says, whatever your as is logic is, address that specifically. We're not going to do a termite clearance. Well, put that down, not doing a clearance. If you're not going to make repairs, put that down. Seller does not intend to make repairs. The buyer can still ask, but that's sort of a preconditioning the buyer up front that, look, I'm not going to agree. So let's not waste time if you think you're going to talk me into it. By the way, just as a little anecdote, those of you who were around when banks were foreclosing, every single bank addendum had the bank will not make repairs. I would say, and I'm not exaggerating, 75% of the time they did. So it's one thing to say it up front. It's another thing to follow through when I got to make this one repair and I can close escrow. Yeah, I think I will. Okay. Right. Sharon asked, if Friday is day 1, isn't Saturday still day 2, but cannot use Sundays as day 3 to perform?
Well, Saturday's not day 2 if it's a 2-day notice. If you gave the demand, or I'm not demand, the notice to perform on Thursday, Friday's day 1, day 2 is not till Monday. If you gave the notice to perform on Friday, did I just say that? Saturday's day 1. If you gave it on Saturday, Sunday's day 1. And Monday would be day 2. The last day, that you have to do an action, by the way, that includes contingency removals. So if your contingency removal, you have a 17-day window to remove contingencies, and the 17th day falls on a Saturday, you have until the following Monday to remove contingencies, because that's an action, and an action that you must perform. You cannot be compelled to perform that action on the last day if it's a holiday or weekend.
Yeah, Walt, I was just trying to clarify that it was just the last day to perform. Anything could not be on a weekend or holiday, but if you've got a 5-day, let's say you've got some 5-day contingency, day 5 cannot be on the holiday weekend.
Correct.
But days 2, 3, 4 can be. So thank you.
Right. Holidays or weekends. Right. All right. So I have a 5-day thing, and I give the notice on Thursday. Well, day 1's Friday, day 2 Saturday, day 3 Sunday, day 4, which is a holiday, is Monday, and day 5's Tuesday. Those days all counted because they weren't the last day. So you're correct. Yeah.
Okay. Vicky commented, I can see this being problematic. I have had agents send attachments that do not open by strange attachments.
Right. Now, Vicky, again, it's important. You got 3 days. You have 3 days to notify them. You can do it with a receipt for reports. I would argue you can do it for the contract references a receipt for reports.
Sorry, Walt, I got the answer to that and the next question that I asked.
Yeah. Okay. Right. But get that notice out right away. Be sure your buyers understand, hey, yeah, you got to open that link. Well, I don't want to, or can't. Well, I got to notify the other side then right away.
Now, I asked a question about that. What if an agent extends that by saying they didn't receive it? Could that be a tactic that an agent can use to extend that time frame?
No, because receipt isn't you receiving it. Receipt is when you send it.
No, but there is that one paragraph, I have to go back to it, where it says that you have to give the other party 3 days notice within 3 days if you cannot open the attachment.
Right. And those 3 days starts counting the moment it was sent. That's what's
even if you let them know on day 2 that you didn't open the attachment, it doesn't open up the window from receipt of that?
I didn't understand what you just said.
So say somebody sends a link for, say, a notice to perform.
When did they send the link?
If they sent it, whatever day it is.
Well, tell me whatever day, hypothetically.
Say it's today.
Okay, today it was sent today.
Correct.
Right.
It
was received today.
Well, no, the agent.
It was by contract. See, that's the important point you need to make. You need to understand. The contract doesn't say when you actually get it in your email. If you have a server that takes an hour, they're going to, that doesn't matter because it's by the day. But if they send it to you at 11:45 p.m. and you didn't see it until tomorrow morning at 1:15 a.m. because your server's slow, doesn't matter. The moment it was sent is when you received it. So
there's this section on K where it says if the recipient of a link is unable or unwilling to open the link or download the documents or otherwise prefer delivery of the documents directly, recipient of a link shall notify the sender in writing within 3 days after delivery of the link.
Right. Delivery is defined by the moment it was sent. That's what I'm trying to tell you. See, before delivery used to be when you got it. That was delivery, And then
I understand that.
Yeah. And the problem you had is proving when they got it. So CAR went the other direction. They said, we don't need to prove when you got it. We just need to prove when we sent it. And they get away with that because the courts kind of do that with email. The courts, with mail, by the way, they sort of say the same thing. They don't really buy into, gee, I never got the mail. They don't like that. They don't accept that at all with email. If you can provide a bona fide email address that you send it to, the courts are going to say you got it. And so CAR simply incorporated that into the contract. So delivery isn't when you received it. Delivery is when it was sent. I can't stress that enough because that is completely opposite of how we've been doing real estate for a long time.
I understand that, but what does it mean about this paragraph where they're saying if the link is unable or unwilling to open?
You've got 3 days. Well, see, when they sent it, it came in an email. The link came in an email.
Correct.
So when they sent that email to you, that's the delivery. You got 3 days from when they sent it to tell them I can't open the link.
Well, sorry, this is Pega. Can I just add something, or I'm trying to be helpful? Sometimes for me, it helps to understand where it comes from, what the reason is.
Yeah.
Perhaps if my question is, maybe this was put in place, the language of the link, the purpose of it is, for example, the person who received the link, maybe they're paranoid about opening links in general because of, spam, or what is it called? They're viruses because malware. Thank you. That's the word I was looking for. So they have the option to say, hey, I don't want to open this link. Please send it to me as, like you said earlier, please send it to me in email, like documents, old school stuff. Yeah,
exactly. No, you're exactly right, Peggy. That's exactly what that clause is about. Where I'm having concern with Vicky's question is, Vicky is focusing, I think, Vicky, you're focusing on when you received the link. It has nothing to do with when
No, I'm not. I've had agents send me attachments where I cannot open the link. They come in some crazy attachment that's impossible to open.
Right. And the offer says if you can't open it, as long as you notify them within 3 days, then you did not receive it. But if you don't notify them, then you did receive it.
Right. That's exactly what I'm saying. So what my question is, so if you tell them, look, say today I got an attachment on an email and I cannot open it. It will not open. Right. So I notify the other agent, hey, I'm sorry, this link does not open. Right. What does that do for, you just said that it's not considered delivered.
Well, no, I wouldn't say it's not considered delivered. I would say you're exercising your right to say, I can't open the link or I refuse to open the link, in which case, as long as you notify them of that, they have to send it to you in a way that's not a link.
Okay, so my question then is, does that open up from receipt the time frame of the 3 days?
No, because it starts over again. Oh, I see what your question is.
It buys you time.
Yeah,
That's what I'm asking. Is this going to be a tactic that agents are going to use to extend those timeframes, those 3 days?
Quite possibly, sure. Yeah.
That's what I was asking.
Yeah.
Okay.
I see what you're saying. So when does the now when you say the 3 days, no, I mean extend. I'm not sure that's going to be universally that valuable. I mean, if you're sending, see, they have 5 days after receipt of these things, or the contingency period, whichever is longer. So, yeah, if you sent a link on the 4th day, well, you've extended their contingency period, and I'm sorry, if you sent a link and there's only 4 days left in their contingency period, we already have an extra day. And then if they screw around and tell you, I can't open the link, yeah, they're going to get 3 more days. So the remedy to that tactic, Vicki, is don't wait until the 8th day to send the link.
Yeah, I'm focusing more on the notice to perform because I've seen in the past, I'm focusing more on the notice.
Wait. A notice to perform should never be sent by a link. Never. So
or say it's an attachment.
Attachments, that doesn't apply. It doesn't apply.
It doesn't apply to attachments? Okay, that's what I wanted to know. Okay.
Oh, okay. No, links. It applies to links, not to attachments.
Okay, perfect.
Yeah. Okay.
Okay. Next was a comment or a question from Judy Spady. I assume an agent can list a fax number if they are 1,000,000 years old.
Gee, I don't know that that's true. That's a good question. I'll have to research that. I don't know if fax numbers are electronic delivery addresses. I don't think they are, quite frankly. Fax numbers do create, our office does that. You fax something to the office, it creates an electronic document. But I'm not sure. That's a good question, but I'm not sure that the fax number applies. You would want an email address. Does that help, Judy?
Yes, very much. Thank you.
Yeah. And by the way, if I'm a listing agent and the buyer didn't provide that in the offer, I would counter that this offer is not accepted, or acceptance is contingent upon agent providing electronic delivery addresses because you're going to want to send them notices. I would argue that listing agents tend to send more notices than buyer's agents, but agents do too. But listing agents, talking about tactics, I can see buyer's agents trying to get away with not providing that to you. Now it'll be a little harder for you to affect delivery. No, I'm not even accepting your offer without, or conditioned upon getting that.
Okay. And then Dave Zeman commented, use an optional initial in DocuSign for arbitration. And Ruben said, for the mediation/arbitration clause, I believe you have the option to not make that initial a mandatory initial. Make it optional.
You might be able to do that in DocuSign. You might be able to put a thing there, but then also say this is not required. So check on that. That's a good point. But let me make one little comment. Separate mediation, arbitration in your dialogue. They are separate. Mediation is boilerplate. Mediation occurs with the exception of going to small claims court or those other courts. They occur. Before you can arbitrate, but arbitration is an opt-in or opt-out. Mediation is not. So it's not mediation and arbitration. If you look at the page they're on, I think it's page 14. I'm doing this from memory. You'll notice that there's a block for liquidated damages at the top. Then there's a mediation paragraph, no blocks, no initials, and then an arbitration block at the bottom. And they did that intentionally to separate mediation out because a lot of people link mediation and arbitration. Just don't do that. Don't do that.
Okay, Janine asked, do both parties, buyer and seller, need to agree on arbitration?
Yes, great question. Yes.
Okay. And then the last question is from Gene Wilson. He asked, does RE/MAX Connections have 2 escrows or only Connections escrow with Barbara Reisner?
Well, we have 2 we have two entities that perform escrows. Barbara Reisner is our in-house escrow officer. There's also Connections Closing Services, which is an escrow done by an entity that is associated with Mike. But they're both broker-owned functions. I'm not sure what Gene, you should specify, if you specify Connections Escrow, it's going to go to Barb. Remax Connections Escrow. I'm not sure what
I was just curious, since Barbara, since Connections Escrow was started, I didn't know whether the other escrow entity was going to go away or stay. So that was my question.
It's going to stay
like both of them.
Yeah, it's going to stay for a while because a lot of agents are using that other team, and that other team has performed well for these. Many agents on this call have no clue who Barb is, but they know, Lindsay, not Lindsay, our Lindsay with an SAY, but Lindsay SEY, escrow officer, and she does a great job for them. And so, yeah, that's not going away for them as well. So,
okay, thank you.
Okay.
All right, that's it for the questions in the chat.
Anybody else have any questions? Did I confuse anybody? Okay.
One quick question, Walt.
Yes.
With the verbiage in paragraph 33 now, when a seller accepts or generates counteroffers, we've fallen into the practice, a lot of agents, none of ours, of course, would respond with a counteroffer only. And we've always asked that they return the entire agreement. The verbiage in the paragraph 33 now says that if a listing agent and a seller generates 3 multiple counteroffers, the seller is obligated to sign and initial all 3 of the full offers when they return the multiple counters. Is that correct?
Yeah, they would have to and return that offer to that specific offering party.
Oh, wait, well, exactly. What I'm saying is if you're generating 3 multiple counter offers, in this market, that's happening all the time.
Sure.
And agents have cut corners and just generated the multiple counter offer forms out and then waiting until they get them back before they decide which one they're going with, and then have the seller sign the full offer. But the way this contract is written now, they're obligated to return the fully executed contract with the multiple counteroffer to all 3 agents and all 3 buyers.
They're obligated to, yeah, whether they do it or not. I mean, as a practical matter, I'm not going to lose a lot of sleep if a listing agent got 9 offers and they multiple countered all 9, but did not have their buyer initial all 9 offers. The problem not doing that is, quite frankly, and I've talked to some agents who do sit down with their client for 2 hours and go through the offer and have them work each one, because how do you document the seller knew what was in that specific offer? See, the problem you get is if you're just shooting off multiple counters and then the seller is in an offer, the buyer accepted one of those multiple counters and the seller countersigned that multiple. Now you're in a contract. And then the seller says, wait a minute, they want what? I got confused. I didn't know these people wanted it. Oh, no, I told you the difference between A and B was B want. See, you got to kind of have a nightmare there, I would say. So the way to avoid that is to put in the extra labor. But again, each agent's going to do what they do. I would argue it doesn't defeat moving forward. If you don't get a copy, ultimately it could defeat moving forward, but you could move forward without doing it. And the other side was okay with it, no harm, no foul, except I would say there could be a harm because your seller is not documenting they know what's on that offer.
Yeah, that's the problem. Is that we've had cases in the past where the agents generated a multiple counter offer, got it signed and accepted, and then refused to provide the full contract and saying that we don't have a deal because my seller never signed the full contract.
Okay, let me address that. That's a great question, by the way. And if that ever comes up, by the way, when you have things that seem kind of foul, it doesn't seem right, that's why you call Larry. That's why you call me, call your manager. But here's what's kind of neat about the law. the person who makes that claim is going to lose outright. Why? Because the counteroffer says, I accept everything that came before this. And then they sign it. And we've been to court where exactly what Larry says, the buyer, we've had a buyer, my wife did an initial page 4, so we don't have a deal. No, you do, because your wife signed the counteroffer. You know, we've had deals. We had a deal recently where the seller didn't sign anything on the offer, not a thing, but they signed the counteroffer. I told the seller, we got a deal. They told me I was nuts and their attorney was going to call me. Their attorney never did call me. They opened escrow 2 or 3 days later because their attorney told them, nope, you got a deal. Because the boilerplate of the counteroffer says, like I said, everything before this we agreed to. See? And so they've documented they agree to it, whether they signed it or not. The nice thing about signing it, especially when you have the client, is they are memorializing, theoretically, they know what's on the page, because I like to use the expression when people say they signed something, but then they say, I never read it. I say, well, you're not insane. So, you sign stuff without reading it? Because once they sign it, I would say they're somewhat obligated by it, morally as well as they are for sure legally, but even morally, I don't buy that argument. Well, I didn't read it. Well, then shame on you. But you want them to sign it. But if they don't sign it, you still have a deal. Absolutely. As long as they sign the counter. Yeah. Good point. Any other questions? I hope we clarified that link versus attachments. Attachments are not the same as links. And I didn't quite understand that in Vicky's question. I apologize, Vicky. That must have been frustrating because I didn't understand that's what you were referring to. And so to summarize on that, do not put notices to perform and things like that in links and put them on the cloud. Attach them to your email, because that's delivery.
Thank you. Thanks for clarifying that.
Absolutely. Okay. Well, folks, thanks for joining me. I hope you got a good handle on it. We're going to do, I think, again, it's the 29th, the Wednesday between New Year's and Christmas. I know most of you will be around. I'm going to do a line-by-line review of those paragraphs. Basically 11 through 22. Those are the ones I skipped because there is some good information in there and some insight. And best learning happens when you're taught something you already know. So you'll come away from that even better informed. But I wanted to skip through that and get to what we did cover today, because as you did notice, there were some significant changes, and hopefully many of you are going to be using that RPA in the days to come. And I wanted you to have this information. So thanks for joining me. Call at any time, and I'm happy to help any way I can.